Hello, welcome back. In our previous lecture then, we looked at what were the legal requirements of an offer. And what we need to look at now is acceptance, because if we have offer and acceptance of that offer, we have the first step in establishing a legally binding contract. So what is acceptance? Well, we have a definition here, an unqualified agreement to all of the terms of an offer. So what does that mean? Well, first of all, it has to be unqualified. So you have to accept the offer as it is. If you try to change the terms of that offer, then you're in danger of making a counter-offer, which is something we looked at in the previous lecture. But also, you have to take all the terms. You can't pick and choose. So imagine I offer to sell you my car and the bike rack that goes with it. Now, if you come back and say, well, yes, I'd like the car, but actually I don't really want the bike rack, that is not acceptance of my offer, because my offer, the two came as a package. What you have done is you've picked certain terms of my offer that you like. So that would actually not be acceptance of my offer. It would probably be a new offer being made by you. Now, in order to accept my offer, normally we'd expect some sort of express words. Ideally, I accept, or yes please, something that indicates that you've agreed to all the terms of my offer. But quite often we end up relying on conduct, so we need some act. Now, in a simple example, maybe you have picked up a bottle of milk in Marks and Spencer's, take it to the counter, you are making an offer to buy that milk at the price that was advertised, remember, because the display of the milk was an invitation to treat. If the shop assistant takes your money, processes the payment and gives you a receipt, that would suggest that she's accepted your offer. Although she may never have actually said, I accept, the conduct is sufficient to establish that she is actually happy to go ahead with the terms of that offer. However, as it says in the notes, some act is required. In my example, the shopkeeper actually took your money and put the payment through the till. In the example in the notes, Brogden v Metropolitan Railway, we had a slightly more complicated scenario. So in this case, Brogden had supplied coal to the Metropolitan Railway. They've been doing so for a number of years. And at some point they decided that they needed to change their terms. So they sent a draft agreement to Brogden for them to sign, saying this is the terms that we're going to do our business on in the future. Now, nobody ever actually signed this agreement, so it wasn't really quite clear what terms the parties were doing business on. And indeed, later on, when a dispute did arise, Brogden said that there was no agreement. However, the court said that they could see by the conduct of the parties that this new agreement had been accepted. And the reason was that both parties had changed the way that they did business in response to the terms of this draft agreement. So therefore, although they didn't sign the agreement, the fact that they'd changed the way they did things to comply with the terms of the agreement showed that they had accepted it by conduct. Now, a very famous case is this case, Feldhaus v Bindley, because that takes that point a little bit further and says, well, you can't accept by silence. And if I talk to you about the case, you'll understand what I mean there. In this case, Feldhaus wrote to his nephew wanting to buy a horse. It's quite an old case, you'll see there, 1862. And he said, if I hear no more about him, I will consider the horse mine. Now, the nephew had intended to accept his uncle's offer, but he didn't reply, and unfortunately, he died. So, Feldhaus was left trying to enforce a contract against his nephew's executors. And the executors said, well, there is no contract because there was no acceptance of the offer to buy the horse. And the courts agreed. They said there was no contract because of the nephew's silence. Silence alone cannot constitute acceptance. He needed to reply in some way and just say yes or okay or something like that. So silence is not enough. And again, pretty important case and quite commonly tested in the exam. You've got that point there, it says no title, so he had no title to the horse. It just means he had no claim on the horse, i.e. there was no contract. Now, if you want to accept a contract, therefore, the rule is that you must communicate your acceptance. So you must tell the offeror. If you don't tell them, they don't know the offer's been accepted, there is no binding contract. So how are you going to accept this contract then? Well, the law says you can accept that contract by any reasonable means, so long as you actually communicate it to the offeror. However, what if the offeror has stipulated a particular form of acceptance? And they may do that. They may suggest, for instance, that you reply by registered post. Now, the law on this is a little bit woolly, because what it says is if you've been told to reply in a particular way, then you should use that way, or a way that is not less expeditious. And there is a case on this where the offeror requested response by registered post, and the offeree replied with his acceptance, not using registered post. However, his letter arrived in exactly the same post as the registered post would have done, and therefore the offeror suffered no inconvenience whatsoever. So because the letter was received in a way that was not less expeditious, even though it wasn't the way that the offeror had requested, then that was valid acceptance. Okay. Now, that's the basic rule. Acceptance must be communicated, but there are some exceptions. Now, we've already seen one of those, and that was the Carlisle case, you know, the smoke balls? Because in this case, remember, Mrs. Carlisle had actually accepted the offer, the contract to go for the reward, by buying the product and using the product. Now, in that case, the offeror is said to have waived the need for communication, and as it says there, in a reward type contract. And we call those contracts unilateral contracts, because only one party needs to communicate the terms of the offer and acceptance. Now, another way the examiner could test that Carlisle type scenario is in something like a reward type contract, maybe a lost dog type contract. So if I put some posters up all around the New Forest where I live in respect of my lost dog, offering a reward of £1,000 for anyone who can find my lost dog, then anyone who goes out and looks for my dog has accepted my offer to pay a reward. Okay? That is also a unilateral contract. Now, someone who finds my dog after looking for it, having seen my poster, looks for the dog, finds him and brings him home to me, he will be entitled to claim his compensation, his reward. However, someone else who perhaps hasn't seen my poster but just happens to see my dog and bring him home to me, he would not be entitled to enforce the contract because he didn't accept my offer. He didn't see the poster, accept my offer and go out looking for the dog. He actually brought the dog home without knowledge of the contract. So you must have knowledge of the unilateral contract in order to be able to enforce it. Now, another exception to the communication rule is something called the postal rule. Now, the postal rule, again, is frequently tested. Remember, this is an exception to the normal rule. And it comes from the days when the post used to take, maybe a week or two for a letter to get from one end of the country to another. And because of this problem, there was a lot of uncertainty in business. People didn't know whether a contract had been accepted or not. So you had this kind of time lag in moving a contract forward. So to deal with that, the courts developed the postal rule. And the postal rule says that if you accept an offer using the post, your acceptance is valid from the moment you post it, regardless of whether it's actually received. Now, that's great for the offeree because he can accept the offer, put his letter in the post box, and he knows that he has a binding contract. It's not that great for the offeror because he may never actually receive that letter, but even so, he's still bound by it. Now, you can imagine that could cause some fairly interesting scenarios. So if you are an offeror and you want to avoid this problem, what you could do is you could stipulate in your letter that you want acceptance by notice in writing. And that overrides the postal rule. It says that the acceptance will only be valid if you actually receive it. Okay, so just watch out for that terminology. Now, in order for the postal rule to apply, remember it's an exception to the normal rule, you must be able to show that the use of the post is within the reasonable contemplation of the parties. So just think about that practically. If you were to wander into Marks and Spencer's and have a little conversation about buying a 3-piece suite, it would be very odd for you then to go home and write to the manager of Marks and Spencer's to conclude your contract, to accept the offer that the man on the shop floor made. Because what we would expect is that you were dealing face-to-face initially and that you would continue to do so. On the other hand, if somebody were to write to you, if I wrote to you offering to sell my car to you, it would be very reasonable for you to write back to accept my offer. Now, there's a couple of evidentiary issues, of course. You have to be able to show that you did actually put the right address on your letter and you paid the postage. So getting proof of postage from the post office would be quite sensible. And this point here is important. The postal rule applies to acceptance only, okay, not to revocation of an offer. So if you think about our previous lecture, when we talked about how the offeror could withdraw his offer, could revoke his offer, and we said that revocation has to be communicated, there is no exception to that rule. The postal rule won't get you around that problem. So if you revoke your offer using the post to do so, your letter of revocation must actually be received in order to be effective. Okay, and then a final point here about instantaneous communication. So email, instant messaging, things like that. The postal rule doesn't apply there. So if you are trying to conclude a contract over the internet, over email or something like that, then you need to make sure that your communication has actually been received, because if it hasn't, then it's not going to be an effective contract. So we've got 2 questions to practice here. These are both exam standard questions, so give you an idea of what you can expect in the exam. So first of all, we've got Oscar. He's got horses to sell, and he offers 2 each to Abby and to Ben for £4,000. He says the offer will stay open till Monday. Abby replies and says, can she have one now and the other in a month's time? And Oscar doesn't reply, so Abby decides to accept his original offer. Ben replies on Saturday, saying he'll take them for £3,500, and Oscar again doesn't reply. So on Saturday, Ben accepts the original offer. So what is the contractual position here? Well, let's look at Abby first. So Oscar has horses to sell and he offers 2 each to Abby and Ben. That sounds like an offer to me, so we have an open offer. He promises to keep it open till Monday. Now, does he have to do that? The answer is no, isn't it? We've already looked at that point. Abby says, can she have one now and the other in a month's time? Now, that is either going to be a counter-offer or a request for information. Well, it sounds like a question, doesn't it? She's not trying to change the terms of the contract. There was nothing in the contract about the delivery dates. She's asking for more details. So I think that is a request for information. She doesn't hear back, so she accepts. So at that point, we still have an open offer. Therefore, we have a contract. Let's have a look at Ben, though. What about Ben? So Ben has the same offer as Abby, but he replies on Saturday and he changes the price. He asks if he can take them for £3,500. Well, that is definitely a counter-offer. Therefore, Oscar's original offer to sell has now been terminated. Therefore, there is no open offer. So when Ben accepts on Saturday, there is no offer for him to accept. That means that Ben is in effect there making a fresh offer, which is open to Oscar to accept or reject. So in this case, Oscar is free to sell his horse to someone else. There is no contract. Okay, why don't you pause the recording for a second and have a go at Frank and Zuzu. Okay, have you had a go? Let's have a look at it together and see if you were right. So, Frank writes to Zuzu on the 1st of July, offering to sell a sailing dinghy. Now, I find it helpful sometimes to sketch out a little timeline. So, on the 1st of July, Frank writes with an offer in writing. And he's offering to sell the dinghy for £1,200. On the 10th of July, having received no reply, he decides to withdraw his offer and he sends a second letter. So on the 10th of July, he sends a letter of revocation. On the 10th of July, Zuzu receives the original letter and responds accepting the offer. So we have the revocation is posted on the 10th of July, and we also have acceptance being posted on that same day. Frank never receives Zuzu's letter and he sells the boat on the 13th of July. So, first of all, we know that acceptance has to be communicated. Now, unless the postal rule applies. Is it reasonable for the parties to use the post here? Well, yes, it is, because Frank made the offer by letter, therefore it's reasonable for Zuzu to reply by letter. So the postal rule applies, which means that the acceptance is valid from the moment of posting, regardless of whether or not it's been it's been received. Frank's letter of revocation isn't valid until it's actually received. So Frank's letter of revocation wasn't effective before the letter of acceptance was posted. So on the 10th of July, we have an offer being accepted by Zuzu. So, indicate whether the following statements are true or false. Well, Frank's letter constitutes an offer which Zuzu is entitled to accept or reject. That is going to be true. Does Zuzu's reply constitute acceptance? Well, yes, it does. And is Frank entitled to sell the boat to Mel on the 13th of July? No, because at that point he has a binding contract with Zuzu. So hopefully you got that right. Now I'd just like to look at one quick topic before we finish this lecture, and that is intention to create legal relations. Now this is quite an important principle because we don't want people to be sort of blind walking into legally binding contracts. So the law says that we will only have a legally binding contract if the parties intended for that to happen. So imagine that you're in the pub on a Friday night with your friends and you agree with one of your friends that you will lend your car to that friend. And your friend's delighted with that and he buys you a pint to seal the deal. Well, technically there you might have offer and acceptance, so you've got an agreement in place and you've got consideration, your friend has bought you a pint. However, when you wake up in the morning and really wish you hadn't agreed to do that, you won't have a binding contract because the chances are that you didn't intend to create a legally binding contract. It was just a social arrangement. Now the problem there is, how do you prove what each party intended? And the courts recognise that, and therefore they have introduced something called rebuttable presumptions. Now what that means is the court will make a certain assumption as to what the parties intended, but that presumption can be rebutted, can be disproved if you like, and it can be disproved by whichever party wants to disapply the presumption. So you disproved by the party who doesn't want the presumption to apply. Now, the presumptions then, there are two of them, depending on the circumstances. The first one applies to what we call a social and domestic situation. So, in a social arrangement, maybe like the one in the pub, the courts assume that you didn't intend to create a legal contract, which makes sense, doesn't it? However, if you want to rebut that presumption, you're going to have to produce evidence which shows that wasn't the case. Perhaps, although you're friends, it was a business deal. Perhaps your friends were also in business together, or perhaps you were buying something from your friend through his business. A lot of the cases centre on husband and wife transactions. And the courts say that if a husband and wife enter into an agreement, we assume that there is not a legal obligation there. However, if the husband and wife are actually separated at the time the agreement is made, then we can assume that they did intend to create legal consequences. So perhaps they agree on their separation that they will, one of them will take the house and will make a payment of cash to the other one in lieu of the house. That sort of agreement would be a legally binding contract. In a commercial situation, it's a little bit harder, because in a commercial situation, the courts assume that you intend to create a legally binding contract, and therefore it's pretty difficult to rebut that presumption. You'd have to produce some fairly interesting evidence. Now, the courts have occasionally looked at cases with this commercial presumption. And in one particular case, the parties had used the words ex gratia, which broadly means discretionary in legal terms. In this particular case, it was a case called Edwards versus Skyways Limited. Edwards was a pilot, and his employers agreed to pay him off to make what they called an ex gratia payment to him. And they wrote in the agreement that this payment is ex gratia, and intending that therefore it wouldn't be legally enforceable. However, Edwards took the case to court, and the court agreed that there was an intention there to create a binding legal contract. It was a commercial agreement between an employer and their employee. They'd reached an agreement, and use of that word ex gratia didn't override that presumption. If you do want to avoid creating legal obligations before a contract has been properly agreed between the parties, you might use the words subject to contract. And you might see that if you've ever bought a house, during the negotiations, the letter will always be headed subject to contract, which means that anything which is written in those letters does not become a term of the final agreement. It's just part of the negotiations. So you can sometimes use that phrase to protect yourself. Okay, so that is the rules concerning acceptance of a contract and also intention to create legal relations. And I think we'll leave this recording there.